All right, so we have moved mostly past the voting stage of the 2020 election and into the challenge phase of the 2020 election. And this phase goes from voting day through December 8th, when all challenges, legal challenges to the election need to be completed, okay? So we're in that stage right now. Let's review which legal challenges the Trump campaign has brought so far, which ones the courts have slapped down, and which ones, most importantly, have any chance of success at all, and why they may have that chance of success. Stick with me. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, we're going to be talking about the legal challenges that the Trump campaign has brought so far in the 2020 election. They only have until December 8th to resolve these legal challenges. And so they are going to be moving very quickly. Now, many of you have seen some claims from both sides about how the legal challenges are going. And don't pay attention to whichever partisan side is talking about the way the legal challenges are going. We're going to give you the hit and miss, but the majority of legal challenges so far have been struck down, but you must understand that the majority of the legal challenges brought weren't likely to change the outcome of the election and aren't always the most effective path going forward, and they still have time to bring new challenges as well based on information that keeps coming out about this election, okay? So we can't judge based on the number of dismissals the validity of the claims. Let me state at the outset, I believe the likelihood of legally changing the outcome of the election is very low. So miss me in the comments with all of the cope and he's your president and stuff. He probably is my president and that's fine. It doesn't matter to me, but we do have legal challenges remaining, and I'm here to explain what those legal challenges are and what the likelihood of the arguments are. As for success, we don't have a ton of precedent on these issues, and that is what complicates the prediction rate of success, and why anyone telling you there's certainty either way is a little bit out there. They're going out on a limb and they're hedging their bets, and that's fine. That's fine. It's not my job to do that. So I'm just going to tell you what is there and what the process is. If you like this election coverage that I've been doing on the channel, and specifically the political coverage that's been going on, please hit like, subscribe, all of that stuff. For now, let's just get into this article, which is by Time. And I will have a link to the article down in the description if you want to check out the full thing. I'm skipping most of their commentary, and we're going to get right into the state-by-state breakdowns of what's out there, and I'll tell you what's important, and then we'll do some legal analysis around the important questions, because those are the ones that may actually determine the outcome of the election, and they tend to go beyond individual states and all of that stuff. But here we go. So first, to compel Philadelphia election officials to stop counting ballots. Federal judge dismissed the request. First of all, this is a very unlikely challenge to succeed, because to dismiss or to stop the counting of ballots would be to disenfranchise legally cast votes. And that is not something the court is likely to do without pretty extreme evidence as to why they should take such an extraordinary measure. All right. Number two, to compel state election officials to allow Trump campaign officials closer observation of the counting process. The state judge ruled in the campaign's favor, allowing campaign officials to observe the Philadelphia process from a 6-foot distance. This is still embarrassing, in my opinion. There should not be a social distancing requirement on counting ballots or observing election officials. We'll see where this ends up going, but the ultimate outcome is that election challengers, poll observers need to be able to observe and challenge the process. That's why they exist. And to have them required social distancing, you got to imagine looking at like a 13-inch laptop screen or an iPad screen from 6 feet away and trying to read what's going on, or even trying to read an 8.5 by 11 or an 11 by 17 ballot from 6 feet away, it's a pretty big task. You can't observe if there are inconsistencies or errors on the paperwork as easily. So, but right now, it's ruled in the campaign's favor that they need to be given a maximum of 6 feet distance that they can observe within. Whoever time consulted says this will most likely affect the pace of the count rather than the outcome, and then gives an unintelligible reason as to why it would take longer to count ballots near the edges of a gymnasium rather than at the center. That makes no sense, but whatever. It's unlikely to affect the outcome of the overall count. The question will be what observation looks like during a recount, all right, or an audit, and what that process looks like and how social distancing plays into that. That isn't contemplated in this lawsuit, and we're likely to see some challenge about that if there is a recount or an audit of the Pennsylvania election, which they have requested. All right, so to compel Pennsylvania Secretary of State Kathy Boockvar and all 67 counties to impose an earlier date for voters to show proof of identification if it was not on their initial ballots. This is part of an interesting question, and this may end up merged into a different issue. The litigation is currently ongoing in this. The presiding judge ordered all counties to segregate ballots if the voters do not provide supplemental identification by November 9th. The ballots with supplemental identification provided after November 9th cannot be counted until approved by the court. This is going to play into the most important challenge that exists on these ballots, and this is a multi-state challenge, and we'll see where it ends up. I'm going to talk about that for the last part of the video, but I'll indicate it every time it comes up. But the real question is, have these ballots officially been cast? And that is the question. If they're not properly identified and they need supplemental information, and it's after the deadline for ballots to be received, and we're talking significantly after, 6 days after, has this ballot officially been cast? There's actually law out there that says no, but not in Pennsylvania, there's not. So that's what we're going to talk about, and that's an issue that could end up at the Supreme Court. So we'll be revisiting that in a little bit. To compel Montgomery County Board of Elections to stop counting mail-in ballots, this litigation is ongoing. There's 600 ballots that apparently had not been placed in secrecy envelopes and therefore not complying with the requirements as alleged. If they were to win this, that is not going to flip Pennsylvania. Pennsylvania is much more than 600 ballots apart, and those 600 ballots are likely to contain votes for Biden. But Biden is already ahead in the state, so this litigation based on this limited set of ballots is not necessarily going to change the outcome. Now, if it were to go up to the Supreme Court and they were able to use this to challenge ballots in other counties, I mean, maybe you find something, but again, unlikely to change the outcome, but it is there. And then this is one of the most important ones, and this is going back to that question we're talking about. They've asked to intervene in an already existing dispute before the U.S. Supreme Court about whether ballots the state received after 8 p.m. on Election Day should count. There's only one case on this, and it's not in federal court. It's actually in Montana State Court, and it's from 1944. And the case law on that, which we'll talk about when we really discuss this issue near the, after we get through all of the sort of challenges that are out there, says no, that they cannot accept elections after 8 p.m. on Election Day, or ballots after 8 p.m. on Election Day. So we're going to talk about that more, and we're going to talk about how that one tends to go. This is probably the most important existing lawsuit that is out there. That's not to say that other lawsuits won't be brought in, but this after 8 p.m. on Election Day ballots question is very, very important and has serious constitutional implications. So here, just briefly, it says litigation is ongoing. Some legal experts are skeptical that SCOTUS will take the case, while others say that even if the justices do, their ruling is unlikely to change the outcome of the presidential election. That second part might be true, but I think they're more likely to take the case this case than any other, as it involves a direct constitutional question about presidential elections and specifically federal versus state authority on those. Again, we'll talk about that, and I'll show you the case law and the relevant paragraph that matters for this purpose when we get there. Nevada. So those are all Pennsylvania cases. Nevada says to impose an injunction on the automated signature verification machines used in Clark County as ballots continue to be counted. Federal judge rejected the request on November 6th, ruling that federal judges should not be involved in state election administration, and there is no evidence Clark County is doing anything unlawful. And this is a problem with how these sorts of cases are brought. Legally, constitutionally, the method by which voting is done, not the time frame, but the method by which voting is done, is controlled almost entirely at the state level. So to bring a challenge in federal court about what is within the purview of the state legislature is not going to get very far, and that has happened here as well. This case is going nowhere. Now, were they to bring this in Nevada state court, they may have a different option. So far, it doesn't seem that they've done that. Next, to compel state election officials to allow the public closer observation at a Clark County ballot counting facility. A district judge rejected this lawsuit, ruling they lacked standing to bring the claims and had no evidence to back up their argument. They appealed it to the state Supreme Court, and they accepted the case, and then the two parties settled, granting the Republicans what they asked for, better observation ability. Again, the absurd aspect of this election in some ways is where the Democrat parties are opposing increased access or exposure by election observers. Not that it actually has a practical difference. It might not. It depends on the individual counting facilities and how they're set up. But what it does have is it looks really bad to say, no, we don't want observers here. We don't want them closer to us. That looks really bad. What the practical application of that will be doesn't really matter. But this lawsuit is done. It is finished. They've settled it out, and the claims are gone at this point. And again, any of these interim counting lawsuits, largely by now, which is November 9th, we're looking at those not having really any impact because the ballots have mostly been counted. So next, we've got in Michigan to halt the counting of absentee ballots on the grounds that campaign officials had not been given access to observe the process as required by state law. This was denied on November 6th. And so the absentee ballots are still being counted. The question is, will those absentee ballots be challenged in an audit due to the lack of observation that was going on? That's a different question, and that is not considered in this legal case, right? Because this is involving the initial count, and now we will be moving on to whether or not Michigan has a recount or an audit. They will have a chance to kind of challenge that under those rules, and we'll see if they do or not. Michigan, Donald Trump fell significantly behind when the Wayne County votes from Detroit and the surrounding areas came in. So it may be an insurmountable difference, even if they're able to invalidate some absentee ballots. You're talking about having to invalidate a whole lot of ballots to go after it. And Michigan may fall under the same sort of issue that we have going on in Pennsylvania, and that remains to be seen. Okay, so to halt the certification of election results in Detroit, Michigan's largest city and a Democrat stronghold, Judge Timothy Kenney denied the motion for injunctive relief on November 6th, saying there was no evidence that oversight procedures had not been followed. So they've denied the motion for injunctive relief. This case may still be going on, but this is to halt the certification of the results in Detroit, not the counting of the results. So the Secretary of State, once they get all of the count completed, the canvassers go out, which is usually a team of, I believe in Michigan, it's 2 Democrats and 2 Republicans. They go and they verify all of the printouts basically that are placed on top of each ballot box saying what the counts are, and they verify that with the unofficial results that have been submitted. And if they match, boom, they're done, and then they are certified by the Secretary of State after that canvassing process. They're asking to halt that certification. If the judge were to halt the certification, it would invalidate the entirety of the vote from Detroit. And that is, again, that's something that's unlikely to happen. Judges tend to want to avoid issuing a ruling that would remove the votes of like 750,000 people. They're not in the business of doing that. And it was really a long shot sort of case. Georgia, there's a request to disqualify about 53 ballots based on what a poll watcher in Chatham County reported. That has been rejected on November 5th. And, so they said, no, there's no evidence. Also, a 53 ballot by itself, a 53 ballot shift isn't going to change the outcome in Georgia, although Georgia is very close. And so arguably those 53 ballots are pretty important in general, because, if there's 1,000, and knocking off 50 makes it 950, and you get closer and closer to whittling things down. And that's how recounts really work. When you're within about a percentage point or a half a percentage point of the other person, and the Georgia race is very, very close, then, every ballot really does matter. However, this has been rejected on November 5th. I don't know if they've appealed that or not, but that's where we're at. So in Arizona, they filed a case on November 7th because alleging that some ballots were rejected because they contained bleeds, splotches, and stray marks. The time is speculating that this is a sort of the Sharpie gate sort of question, that the ballot readers were apparently not reading Sharpie marker marked ballots. That has been disputed, but this was dropped on November 7th, which means the Republican National Committee stopped pursuing this lawsuit on November 7th. They haven't provided a reason for that. No idea what their reasoning was for anyway on that. It's gone. This case is over as well. So that leaves us with the main case, the most important case, and we can go back up to it here, and it's in Pennsylvania, and this is after 8 p.m. on election day, whether the ballots received after 8 p.m. on election day should count. Now, this is not a Pennsylvania only issue. It'll start that way. It starts that way, but the greater constitutional question is, can a state extend beyond election day? Can a state extend beyond election day the receipt of ballots? And only one court, the Supreme Court of Montana, has ruled on this, and it was in Maddox versus the Board of State Canvassers, 1944, May 22nd, 1944, Supreme Court of Montana. And here is the ultimate part of their ruling that really hits home on this issue. Being within the powers expressly ceded to the limited federal sovereignty by the people of the United States, and having been exercised by the Congress, it is apparent that the states have no power to interfere. Thus, the legislature, the state legislature, may not constitutionally extend beyond the Tuesday after the first Monday in November, the time when the presidential electors shall be appointed or elected by the ballots of the voters. Okay? Now, that's written in a kind of confusing way, but let me break it down this way. The powers expressly ceded to the limited federal sovereignty by the people of the United States is referring to Section 1, Title 3 U.S. Code, and specifically Section 1 of the United States Constitution, which says that the federal Congress shall set the time for the choosing of electors. Now, some people have speculated, even in comments on this channel, that means that you can't allow early voting. That hasn't really been sustained in any court, but the courts have sustained that later voting than this is not allowed. That That is the purview of the federal government, of the federal legislature, to set the deadline by which votes need to be cast and electors chosen. And the reason they have this is because you have approximately 35 days from election day to the time when electors need to be certified and cast their ballots in December. So since you have this window of time, they can't allow longer extensions of receiving and depositing ballots because it messes with the process, I guess. It doesn't seem like it would. I mean, today with telecommunications the way they are, it seems like you could actually have the electors chosen on December 7th and have them cast their votes on December 8th. But that's not what's actually written down, and that is not the law. So despite the technological advantages we have over 1944 and certainly over 1791, we still are bound by the laws and specifically the Constitution. All right. So this is a question that may go up there because the question is, can these states receive a ballot after Election Day? In this case, November 3rd. Now, in Pennsylvania, in Georgia, in several states, North Carolina as well, Wisconsin, there are questions about certifying ballots that came in and need signature certifications. Like the ballot came in and the identification of the voter is unclear. So they've given them time beyond Election Day to remedy or cure the default or the faulty identification. And they may not be able to do that. That may not be a legally cast ballot. In the Maddox versus Board of State Canvassers case, it said a ballot is only legally cast once it is marked and then placed in the ballot box. Placed in the ballot box, that is the time that it is legally cast. Now, if it is an invalid ballot going into a ballot box, then it's invalid. If it's untimely, there isn't a time to cure an invalid ballot. It's cast. There is a deadline as to when these things can happen. So this is the challenge that bears the most potential fruit for the Trump campaign. Will it be enough to overturn the election results? It might be. It depends on if there are enough late cast ballots or late verified ballots or whatever in Georgia, Wisconsin, Michigan, Arizona, Nevada, Pennsylvania. Any of those states, potentially North Carolina, which hasn't been called yet, although it looks like it will still go to Trump. Any of those states, changes in how those electoral votes are decided could sway the election, especially 2 or more states. All right. So that's the area where the Trump campaign has the best avenue of lawsuits sent so far. And let me just refresh that because I know there's a lot going on and a lot of words coming out of my mouth, but it's, can a state, this is the issue the Supreme Court of the United States is likely to take up of any of the issues presented so far. Everything else belongs in state court. But if this goes to the Supreme Court, and with we now have a quote unquote 6-3 majority on the court with a likely 5-4 majority for Trump on these election issues, that's the speculation. There really isn't a likely or unlikely about it. That's what people have speculated. But the issue the Supreme Court may take up is, can a state Congress extend the time to receive or validate or certify a ballot beyond the close of the election day? If they can't, then a whole bunch of ballots do get thrown out. What that number is and how that impacts election numbers remains to be seen. But that is the question. And the Constitution and how the Montana Supreme Court in 1944 read the Constitution would suggest no, that they have no power at the state level to extend the deadline beyond Election Day that was set by the federal Congress, which power was given to them in Article 1 of the United States Constitution. So we'll have to see how it goes. I hope this has found you, or I hope you found this to be educational and informative. I'm trying to present this in the least biased way, not because I don't have a bias, but because I know there's a bunch of spin coming out of both camps on this issue, and I think it's pretty important to do this in a muted and sort of toned down manner without any of the hype. And in this case, I'll again reiterate, I believe the likely outcome is this election will not be changed by the courts. There could be a recount or an audit that changes something, but I do not believe the courts will do this. But the best possible chance that the Trump campaign has at the moment of getting the courts to intervene is on the timeliness of cast ballots and whether or not there are a whole bunch of ballots that were included in these counts that are invalid. And what happens from that ruling may impact the election. So we'll have to watch and see. If you want more election news, keep tuning into this channel. Subscribe, share, all of that good stuff. Let me know what you think in the comments. Let me know what your legal opinions, your illegal opinions, and any questions you might have, and I'll try and take a look at them. All right? Thanks for watching, guys. Have a good day. Peace. Peace.